Good afternoon, everybody, and good morning for those on the West Coast. Thank you for joining this Dentons Academy on federal contract terminations. This is our federal contract termination checklist presentation. I'm going to give people about 30 seconds to get settled in the virtual room. Some people are still joining, so we'll just wait a moment on that, and then we will get started. Just as a brief roadmap, I'm going to start with some of the CLE information to the extent those of you folks are interested in CLE. We'll have a code in the middle of the presentation, which we'll stop to give you, and then we'll have some concluding remarks about how to submit your CLE request. So with that, I think everybody's had I think we can see on our end that the room, all of our attendees are here, so I will get started. So again, welcome everybody to this Dentons Academy Federal Contract Termination Checklist, what you need to know about settlement proposals, cost recovery, and finding the way forward for your business. Terminations have been in the news a lot this year. There's been an unprecedented increase in the number of contract terminations that we're seeing. Some of you may have encountered that. We're hoping to demystify some of that and give you priorities to keep in mind. Before I get started, I'm Evan Sherwood. I'm a partner in the Washington, D.C. office of Denton's Government Contracts Group. I'm joined today by my colleague, Morgan Murphy. Morgan, I'll give you a moment to introduce yourself.
Hi, everyone. My name is Morgan Murphy, and I'm an associate in the Denver Government Contracts Practice Group, and happy to be here today to talk about a really important topic.
And if you need to get in touch with us, here we are. By the way, please, as we go, if you have any questions, submit them in the Q&A function. We will do our best to read those as we go and answer them live. We love questions. It makes this more responsive for you and is helpful to everybody. So do not hesitate to ask questions. If you have a question after, feel free to reach out as well. So we want to start with a really foundational question. When does the government have authority to terminate a federal contract? The circumstances where a government can do that are generally set out in the contract itself. If a contract does not have a termination for convenience clause or a termination for default clause, then there's going to be a question of whether the government can terminate. However, for the most part, and by the way, today we're talking about FAR-based procurement contracts. We're not talking about grants and cooperative agreements. And when you're talking FAR-based procurement contracts, there is ordinarily going to be a prescribed termination clause, both a termination for convenience clause and a termination for default clause. The precise terms of that will vary by your agreement. The terms primarily differ between fixed price contracts and cost reimbursement contracts. A termination for convenience clause gives the government general authority to terminate an agreement in its best interest. The case law, which we'll talk about in a moment, sets a backstop for that of bad faith. In other words, as long as the government's acting in good faith, not acting in bad faith, it generally has authority to issue a termination for convenience if the clause is present. But contractors get a right too. The right that a contractor has in response to a termination for convenience under this clause is to submit a termination settlement proposal requesting reimbursement of costs. Now, a termination settlement proposal and request for reimbursement of costs doesn't give you your lost profits, so it doesn't necessarily mean you're going to be in as good a situation as if the agreement had not been terminated. But that's still a substantial right to make the best of a bad situation, which we're going to talk, most of it today is going to be focused on talking about that. The recent terminations you're reading about in the news are by and large terminations for convenience, not terminations for default. Terminations for default, of course, do not come with a right to submit termination settlement proposals. And if anything, the government may make a monetary claim against the contractor. I'll just ask our team, by the way, Brian, I think there's a green arrow on the screen. If that could just be moved aside, please. Thank you. So what are your basic options for responding to a termination notice? Well, there's a lot of different pathways, but two general channels. You can challenge the termination or comply with it. We'll talk about challenges for the next couple of slides, but not to bury the lead, challenging a termination notice is very difficult. Very, very difficult. For the most part, the prudent course is going to be to comply with the notice. But let's talk about your options for challenging a termination notice. There are three principal options that I want to talk about today. One is if the contract itself does not have a termination clause. The government needs a contractual right to terminate. If it doesn't have that, it can't terminate. The trouble is, for FAR-based procurement contracts, there is longstanding precedent that says the government can read in a termination clause, even if it's omitted. That's the GL Christian and Associates doctrine, dates back to 1963. So in most cases, even if a procurement contract does not have a termination clause, the government's going to be able to read one in, but not all. There are situations actually where this rule would not apply. This is not an every time rule. This is a facts and circumstances rule. And while the facts and circumstances may be common, it is worth looking at if you get a termination and you don't think there's any termination clause in your agreement. Just as one example, federal leases don't normally have your standard termination for convenience, right? And there are other types of agreements where the startup costs are so high, you might actually have a position that the Christian doctrine doesn't apply, but this is an exceptional case if you find yourself there. Another ground is procedural defects. If you get a termination notice, but it's unsigned or it's signed by somebody you don't recognize. And earlier this year, there were a number of instances where folks saw that happen. Well, in that case, there may be a legitimate question about whether the termination is valid. This is a difficult road to go down, though, because even if you think the termination is invalid, it's easy for the government to fix that error, right? If you bring a lawsuit based on that, the government can go find an authorized official and have that person exercise the authority. So it's difficult, but I want you to be aware of it. The last one we want to talk about is bad faith. The government cannot terminate a contract in bad faith, but that's a very high bar. Case law talks about situations where a contracting officer had specific intent to injure or had bias or was acting for discriminatory reasons. Short of those types of showings, it will be difficult to challenge a government termination for bad faith. One question that has come up this year is if a termination happens for reasons that may be unconstitutional, is that bad faith? That's an open question right now, but it just goes to show there are other circumstances you may want to think about. Bottom line here, though, is that it's very difficult to challenge a termination. One of the other reasons it's difficult to challenge a termination is that it's not just hard to come up with a substantive reason to challenge the termination, but it is also it can also be difficult to find a procedural pathway to challenge a termination. Federal court jurisdiction is limited, as we probably all learned in law school. If you have a government contract dispute with the government, you're probably looking at one of a few jurisdictional statutes. The Administrative Procedure Act, which gives courts authority to enjoin violations of law or arbitrary and capricious conduct, or the Contract Disputes Act or Tucker Act, which the Contract Disputes Act gives the Board of Contract Appeals and the Court of Federal Claims authority to enter orders for money damages. Tucker Act also gives the Court of Federal Claims in a wide variety of cases, including non-procurement cases, authority to enter orders for money damages. But if you're challenging a termination, which one of these are you in? Do you want your contract reinstated? And is that a claim for injunctive relief under the APA? Or do you want lost profit damages, which is a monetary claim? Well, the Supreme Court has been going through this right now. This is actually a very live area of the law. The Supreme Court is sending the case law more and more in the direction of if you have any kind of monetary remedy or a claim under a contract, it looks more and more like a contract claim under the CDA or the Tucker Act. But it has not closed the door on APA relief if you have non-monetary claims, dignitary harms, irreparable harm to your business. So if you find yourself in that situation where you think a termination is wrongful and you think you have a substantive claim, it is worth exploring this. But this is a very difficult road. I want to start on it because for completeness, I think it's important to discuss this at the beginning. Most of the rest of this presentation, we are going to talk about submitting termination settlement proposals. In other words, complying with the termination notice. Just to check, I don't think we have any questions in the chat so far. No? Okay. Some more folks have joined. I had skipped this at the beginning. There's a little CLE information I want to pause and comment on now that we have some more folks in the room. So just to add on that point, we can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar, and I'm reading from a little script here, so if it sounds like I am, it's because I am. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining on a mobile device. One other important note, if you have a New York or New Jersey license, please be sure to listen for the code word, which will be somewhere around the middle of the program. When prompted, you'll want to enter that code in the Q&A section of the screen. If you don't have a license in these states, you can disregard this. Again, I said this at the top, we've got a Q&A. If anybody has questions as we go, please don't hesitate to submit a question. We love answering the questions.
So we have question 1 here. And for these, there's going to be a couple of questions throughout. Encourage you all to put an answer in the chat. Again, as Evan mentioned, participation makes these a little bit more exciting, engaging, or otherwise we'll just make your Tuesday a little bit better, and it will make Evan and I's Tuesday much better as well to actually see some engagement. So question 1 here, I'll start going through it. Please put in the chat answers. Contractor X receives a termination notice, but it does not specify the ground for termination. What would be the significance of that? And just because I don't see anything in the chat, so I think folks need a little more time to think. Second part of that question is going to be, suppose the termination notice is unsigned and there is no termination clause in the contract. What might that mean? So on the first one, I'll give some folks ideas, kind of get the well pump going there. If you've received a termination notice, but you don't see any specification for the grounds for that termination, what's going to be the significance there? Well, one, you'd want to let the government know why you think that they are terminating your contract. What you're not going to want to do is probably get too bent out of shape over this one, because really what happens is this is a very easy fix for the government. It's predominantly just a procedural defect. So what you're going to want to do is you're going to want to let the government know, here's what we think the reason is for this termination. You could generally assume oftentimes it's going to be a termination for convenience. And once you've let them know that, you can see if they go ahead and go back and fix that defect. If they don't, then there's more steps that you could take from that point. But essentially, you want to let them know why you think that your contract is being terminated. And on the second question, where you have a termination notice that's unsigned, and there's no termination clause in the contract. One, Evan gave that one away earlier. Standard termination clauses are going to be read in pursuant to the Christian doctrine. So that's a bit of a softball for folks, and I think everyone's pretty familiar there. And then also you do need to actually have a signature on there, and it needs to be a signature for an individual who is an authorized official. So again, you're going to be looking for that signature. If you don't see that signature on there, that's going to be something that you're going to want to raise in your conversations with the government.
One more item on this. It is unfortunately not that uncommon for the government to issue a termination notice where they don't specify, is it for convenience or default? And when they do that, it's important to say, we understand this is a termination for convenience for 2 reasons. One, it sets up that you're going to submit a termination settlement proposal. And there's a timeline on that we're going to talk about in a moment. But it makes clear that that's how you're construing it and that's what you're going to do. So they can't say to you later, oh, we didn't invite a termination settlement proposal. The other thing is that once the government terminates for convenience, it's very difficult for them to go back later and convert that to a termination for default. So you want to make clear as early as you can, you're construing that as a termination for convenience, so that in part so that they can't go back later and say, oh, we meant to do it for default. So don't let that go. Right, if you get a notice that doesn't specify convenience or default, you share the answer with them.
One thing, Brian and the rest of the team that's helping run this, if you can check, we got a note that the chat is disabled. If we can look into that, I'm not sure what's going on there, but that would be helpful just to make sure we can have that chat active.
Yeah, and it looks like we have a Q&A function and a chat function. So, whatever is the best way for folks to get their questions over. And Brian, I see that green arrow on the screen again there. If you could move that aside. Okay. So there is a 3-point checklist. We're going to talk now about complying, right? We talked about how do you challenge a termination, or how to consider challenging a termination notice. Again, it's going to be difficult to do
The
that.
chat is now open.
Okay, thank you. It sounds like the Q&A, yeah, either of those works for us, Q&A or the chat. So we want to now talk about complying with a termination order. If you get a termination order, very likely the prudent course is going to be to comply with it and submit a termination settlement proposal. There is a lot you're going to have to do if you get a termination notice and you intend to comply with it. We want to break it down to 3 parts, okay? So you come back to this. We're going to talk in more detail about each of these, but this is what you start with and come back to. 3 points. You want to stop work and take reasonable steps to reduce your costs. That may mean terminating subcontracts, that may mean downsizing staff, that may mean stopping purchases, that may mean all sorts of things, stopping travel. The steps need to be reasonable. The government understands that when you get a termination notice, you usually cannot instantaneously stop the spending of money across your enterprise. So you want to be thoughtful and deliberate about how you start to wind down and reduce costs. You're also going to want to track those costs because, as we'll talk more about, a termination for convenience, at least for non-commercial FAR-based contracts, which is, I think, the case study we're going to look at today, the FAR essentially treats a termination as a termination settlement proposal as a cost reimbursement type proposal. It's a cost-based proposal. So even if you had a fixed price contract, you might suddenly find yourself needing to track your costs. That may mean setting up new charge codes. That may mean, and even if you're already tracking costs with a fairly high degree of fidelity, you may need to set up new charge codes for your termination settlement administrative expenses for the time spent on the termination settlement proposal. That's one. Two, take stock of property. Your property, inventory, the government's property. You want to protect and preserve that. The settlement process can take a while. You might have inventory or government property that needs to sit in a warehouse or sit somewhere. You're going to want to maintain that because at the end of the day, you may get disposal instructions from the CEO, or you may want to claim credits for those things. You want to be a good steward of those assets so that their value is maintained for the settlement process. Third, make a plan to prepare your termination settlement proposal. To claim termination costs, you have to submit a settlement proposal that explains your cost, explains why they are allowable, and meets a variety of other administrative criteria. It can be a lot of work to do that, especially because if you have subcontractors that need to be terminated, you need to sequence terminations with them before you can finalize. You need to terminate them and settle with them before you can finalize your own prime proposal. And everyone should be mindful that under FAR Part 49, which again is for non-commercial contracts, there's a 1-year default deadline for submitting a termination settlement proposal. A lot of agencies will apply that to commercial agreements as well. We have a question in from the chat. The question is it typical for the government to assign a new termination CO once the notice is issued? The answer is, yeah, it's very common for a termination contracting officer to be assigned who administers the termination. Sometimes that person will have more experience with terminations and can administer it more smoothly because of that. Sometimes the PCO will hold on to a termination and do it themselves. It really depends. It's not a bad sign if you have a termination contracting officer assigned. Yeah, not necessarily a bad sign at all. So thank you for that question. Okay. Morgan, I think you were going to address this slide.
Yes.
What are termination settlement proposals?
So as Evan just mentioned, it's going to be that third step in the process there, where you're actually going to be preparing the proposal. And the proposal is going to be identifying essentially why you're entitled to a payment, what that payment is. And a lot of what's going into this is, one, you're going to want to make sure that you've created a plan as you're preparing to submit your termination settlement proposal. Why do you want to create a plan? One, there's a deadline. There's that 1-year deadline that Evan previously mentioned. Two, you're going to need to get folks into place to help make sure that you are actually recording all of your costs properly. Oftentimes, right, you're setting up a new charge code, and you're otherwise going to want to make sure that you're tracking those allowable versus unallowable costs, as well as any costs that might be directly associated with unallowable costs. So there's a lot of tracking that's going on. So by starting off by creating a plan, you're figuring out, one, what you need to include in that termination settlement proposal. When do you need to get it done by? And do you need to bring anyone in to help you with that? Oftentimes you see that companies are going to bring in someone with some specialization in accounting to help you kind of account for how those costs are being handled. And also legal counsel as well. Oftentimes you're going to bring legal counsel in to help you, particularly if you have a more complex termination, or if you have a termination perhaps that involves a lot of subcontractors, because you're also in the process of setting up this termination settlement proposal. You're working with your subcontractors as well, if you have them, to figure out what cost do you need to get from them to then pass along to the government. So this process has a lot of moving parts associated with it, which is why you want to start off with that plan, and within that plan outlining who you need to have involved to help set it up, as well as what you need to be tracking to make sure that when you're asking the government for that final dollar amount, you have support for it. And if the government does end up pushing back on that final dollar value, you can say, well, here's all of our documentation, here's all of our charts, here's everything that we did to show you why these are allowable. Because this can get pretty costly pretty fast, as you see in that last bullet point. A mistake in the proposal can be costly, not only in what you're able to recover in that final dollar value, but also just in legal costs if you ultimately end up fighting the government over what that number should be. These can quickly get pretty complicated. And so I think the key takeaway when you're preparing a termination settlement proposal is record as much as possible. More information has never been a bad thing. And so you're going to want to record as much as you can, and make sure that you have that critical documentation. Move on to the Evan, anything you want to add to that?
Yeah, look, you'll hear a lot about terminations being litigated. You don't want to litigate a termination. The government doesn't want to. We don't want to. Nobody wants to litigate these things. You win at the administrative level by writing a termination settlement proposal that empowers your customer to give you what you need, right? By explaining to them why you're entitled to it under the contract and why the financial data supports you. That's where these things usually get stuck, is disconnects on what's the financial data and why does it support you. If you provide enough information for your contracting officer to get to yes here, you can avoid many, many headaches.
One slide too far. So we'll go back to, this is just covering FAR Part 49, termination for convenience. So 52-249-2, right? This is going to be, this part establishes policies and procedures relating to the complete or partial termination of contracts for the convenience of the government. And so here really what you're going to see is identification of notice requirements, those methods of settlement, duties of prime contractors, duties of the CO. I kind of described it's a recipe book for everything that you really need to have when you go to this portion of the FAR. And then just in the interest of time, I'll briefly note that the FAR Part 31 cost principles are going to apply. So just something to keep into consideration when we talked about having accountants potentially come in and tracking those costs. Just keep in mind, kind of the back of your head, that you do have the application of those cost principles.
And by the way, if you need accounting support or legal support for that matter, the clause explains that costs of consultants, of accountants, of legal experts to help you prepare a termination settlement proposal are generally allowable as termination settlement costs. So, if you need that help, it's very much there.
Then Evan, I'll hand it over to you to get through some more slides.
So we're going to talk a bit about cost reasonableness, which we've mentioned a few times. It's a hugely important concept when you are administering a termination, both for your own costs and your subcontractor costs. The government will only pay costs, will only treat costs as allowable that are reasonable. What is reasonableness? Thankfully, FAR Part 31 gives us some guidance on this. There's a FAR Cost Principle 31201-3. We've got on the screen. We've got some key quotes. I'm going to read it. A cost is reasonable if, in its nature and amount, it does not exceed that which would be incurred by a prudent person in the conduct of competitive business. There's two parts of that I want to pull out: nature and amount. The cost needs to be the type of cost that a business would ordinarily incur, and it needs to be reasonable in amount, which essentially means not too high, right? So the government's asking, if you have a cost, why is it a legitimate cost of business? What did you do to get a good deal? And why is it my responsibility? And if you take a step back from this, as a policy matter, it makes sense that the government would ask this question. The government is concerned, has general concern, that in any kind of cost reimbursement situation, a contractor or a subcontractor might say, well, the government's going to pay this, so this is an invoice I got, we'll just turn it over to them. The government wants each person in the chain to look at their costs and decide, are these legitimate costs of doing business? Are these reasonable costs of doing business? There's no bright line rule for doing that. There's 4 factors. This comes from the FAR. We've got them on the screen. Are these costs that are generally recognized as ordinary and necessary for business? Are they the result of arm's length bargaining and sound business practices? Are they consistent with a contractor's normal policies? Did a contractor incur a new type of cost for the first time that's very unusual? The government will look at those kinds of things, and it will look at them when it's reviewing your settlement costs in your termination settlement proposal. There's some case law highlights we could walk through on this. The point is, this is in fact an issue that's contested all the time in these matters, and so you want to be ready to demonstrate why you needed to incur the cost you incurred. This goes back to what steps did you take to reduce cost once you got that termination notice. We'll get into a couple examples of this later, but contractors may need to downsize staff or downsize their vendor pool after a termination because they don't need the same level of support. Maybe your vendor agreement requires 2 weeks notice before termination. And maybe that was commercially reasonable because your vendor wouldn't have done business with you unless you agreed to that term. Well, in that case, you probably you're in a good position to say to the government, I needed to incur an additional 2 weeks of costs after termination because I couldn't get out of that agreement any faster than that. But if the agreement allows immediate termination and doesn't have wind-up costs for a vendor, and the vendor's paid for 2, 3, 4 weeks after termination, well, the government might say, well, why is that reasonable, right? What did you do to reduce those costs? Being able to show your work and your thoughtful process on that is going to be really important in prevailing on the termination settlement proposal. I won't get into the specifics of these cases. Just know that these are good examples of that type of question. Because again, as Morgan was saying, when you get a termination notice under FAR 52249 and its variants for non-commercial agreements, your work is essentially converted into a cost reimbursement, or your agreement is essentially converted into a cost reimbursement agreement in which you need to submit a cost-based termination settlement proposal. So all of these cost concepts become critical. And these are areas where it's very easy to make a mistake, especially if you were working on a fixed price contract to begin with. Another one of those areas you're going to want to be mindful of is allocation of cost to contracts. The FAR tells us that all costs are either direct or indirect. They're incurred specifically for a government contract or other final cost objective, in which case they're allocable 100% to that agreement. Or they're indirect. There's something that benefits a government contract and other work, but can be distributed in reasonable proportion to the benefit received. That could include, say, management oversight of a manufacturing floor, right? There's also indirect costs that are necessary to the overall operation of the business. Pension plan, lease costs for the headquarters. These costs are going to need to be accounted for based on their characteristics. You may have costs that are 100% allocable to the terminated contract or to the termination. And distinguishing those from indirect costs is really important because it's going to allow you to claim those costs in full. Your termination settlement proposal, by the way, does bear its fair share of indirect costs, so you're going to want to be mindful of burdens for that reason too. But again, we bring this up just so that folks can be mindful of these principles coming in to agreements that may not have had to deal with these problems to the same degree prior to termination. Another topic is allowability. Allowable versus unallowable costs. FAR Part 31 provides allowability rules. These are rules about what costs the government will or will not, as a matter of policy, pay. Some classic examples of unallowable costs are the cost of alcoholic beverages, right? So if folks go out to the bar the night of the termination to commiserate over the bad news, those are not going to be allowable costs, right? I don't think anybody would think they are, but there are other types of costs that can come up in a termination scenario that may, to a business team, seem like a very reasonable cost that are otherwise not allowable, such as interest on borrowings. Interest on borrowings are generally unallowable. Contractors may say, well, with this terminated contract, I had my revenue stream disrupted. I needed to take a loan to cover the period of time, especially if the termination period wind-up period can last a long time. Interest on borrowing is generally not allowable. And so while that might seem like a cost that's incidental to a termination, that's not going to be an allowable cost. You do need to consider and account for unallowable costs. They're very important for all sorts of cost accounting reasons, including that unallowable costs need to bear their fair share of burden. So they usually need to be included in the base when you're allocating indirect costs.
We have a question in the chat.
Yeah. So let's see. We have a question. Ray, downsizing. Is it reasonable to consider the impact on the business as a whole, or is the analysis limited to the terminated contract only? This is a great question. Reasonableness is not limited to just the one contract. It is reasonable to the business as a whole. So to give you an example, in the termination cost principle, which we'll talk about in a moment, the government says if you have tools or items that are useful to the business overall that you can still make use of for your other work, they're going to be very skeptical of those being of cost of those being treated as termination costs, because they're going to say, go use that in another part of your business, right? If you have tooling that can only be used on that contract, maybe then then it's a very different situation. But that's true about your termination costs generally. You may have folks in overhead positions that are not needed anymore as a result of a termination, right? I mean, that goes to the larger business. You know, their portfolio might have gone from 50% this contract to 10% something else, and you have questions about what can be sustained. So the short answer is no. You get to consider reasonableness on all facts and circumstances bearing on reasonableness, including the impact on the business as a whole. Your CEO, you may encounter auditors or CEOs who question that, and if you do, let us know. We'll help you walk through that with them, because that would not be correct. Just to give you a flavor of the range of cost principles there are, we've got a couple examples on the screen of ones that can come up: employee compensation costs, depreciation, IR&D, insurance, all sorts of things. We do not have time to go through all of these. What I want everybody to know is, if you're including a cost in your termination settlement proposal, think about whether there's a cost principle on point and whether it gives you any guidance about how to handle it. There is a cost principle on termination costs, FAR 31205-42. It is wonderful guidance. It's very, very helpful. The debates you might get into with auditors or the CEO, you can often resolve by reference to this clause. So one of the things it says is that initial costs are generally allowable. What do we mean by initial costs? Well, those could be your startup costs, right? If you may have started work and planned and done significant investments in the first month, planning on a year's worth of revenue coming your way that was going to make up for that. But if the agreement is terminated 6 weeks in, you may not have had the revenue stream to account for that. Well, this cost principle gives you a basis to claim those costs as reasonable, saying, oh, look, these are initial startup costs that we needed to do to be ready to do the work. It also includes other things, like one example I love, spoilage from inexperienced labor. You might have had a high rate of defective units or inefficiency at the very beginning because you didn't get anywhere into your learning curve that you were anticipating. This cost principle tells you the costs associated with that can be allowable when reasonable. Another one is continuing costs. This is key. I said earlier, the government understands that you can't just stop costs the moment that you get the termination notice. Your whole enterprise is doing things. You generally can't just stop. Well, if a CEO or an auditor ever asks you, well, where does it say that in the FAR that your continuing costs are allowable? Well, it's in this cost principle. The catch is you need to make reasonable efforts to reduce those costs. So as long as you're being reasonable, and this is why we talked about cost reasonableness, as long as you're being reasonable, the government should be on the hook for continuing costs in the time it takes to wind them down. We'll talk about some examples of that in a moment. Severance is one, leases is another. There's a lot of interesting costs there. This cost principle also talks about loss of useful value. You may have had tooling or special tooling or machinery for that contract that you don't need anymore, or that has very little value to your business. There's a generally accepted accounting principle concept of impairment that sort of comes into. The point here is if you have lost value in tooling or other capital assets, and it's not reasonably capable of use in other work. If it is, it's a different story that you still have options for recovering it. But if you've lost value, this cost principle gives you options for pursuing that. The last one I want to talk about, this is not everything in the cost principle. This is just a selection, by the way. The last one I want to talk about is unexpired leases. You might have signed a 1-year lease to perform the agreement. but the agreement's terminated 4 weeks in. And you say to the government, well, I got to pay this lease for a year. The government's going to ask, well, why did you sign up a 1 year? Why did you sign up for 1 year? Well, I was expecting the agreement to last a year. Okay, you didn't want to negotiate an early exit clause? Well, I wasn't anticipating that. And if I'd asked the landlord for an early exit clause, they would have increased the rent 50%, which would have been expensive. So no, that wasn't commercially reasonable. All right, see, we're back in cost reasonableness. Okay, so it was reasonable to negotiate a 1 year lease. Sure, great. What can you do to get out of it or reduce your costs? There's no early exit provision? Okay. Can you sublet it? Can you find a sublessor to come in? Maybe you can, maybe you can't. You'll want to show what efforts you took to do that. And if at the end of the day, after reasonable efforts, you can't get a sublessor and you can't get out of it, I think you'd be decently well situated to claim that year's worth of lease costs. I've got the quote from the relevant part here. All reasonable efforts to terminate, assign, settle, or otherwise reduce the cost of such lease. If you can show you did that and you've still got lease costs, then this cost principle says those costs resulting from termination should generally be allowable. We have come to our CLE code word, and there is something I'm supposed to read. So I'm going to read that now. As mentioned earlier in the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. Code word is termination. All New York and New Jersey licensed attendees must type the code word termination into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time or are not able to see it on the screen this very instant, the code word is termination. I am not seeing many people enter this code word. Perhaps we do not have too many people licensed in New York or New Jersey, but now is the time. I'll give everybody about 10 more seconds and then we will continue. Okay, we are continuing. I want to pause and spend a few minutes talking about subcontract terminations. If your prime agreement is terminated, you probably have subcontractors, vendors, and suppliers who are supporting that, who you don't need to the same degree, or maybe at all. These can be, in my experience, some of the largest elements of your termination settlement proposal is your subcontract termination costs. There's actually a sequence here. The FAR contemplates that you will settle with subcontractors first, then include those costs in your prime proposal. Now, you may be thinking, how do I settle with the subcontractor first if I don't know what the government's going to do with my proposal? Well, you can make these settlement agreements conditional. There's a lot of nuance and a lot of art to this. It depends on the terms of your subcontract, the relationship with your subcontractor, but it's extremely important to get this right because you don't want to be on the hook. You don't want to have paid out to your subcontractor and then find the government later saying, no, you can't do that, or we don't think those costs are reasonable. This happens from time to time. It can be an enormous headache. It can drive disputes. Sequencing this and having everybody thoughtfully on the same page about where we're headed is extremely important to avoid disputes. Subcontractors usually do not have any rights against the government in the event of termination. Okay, they've got to go to the prime, or a lower tier sub has to go to the higher tier sub, who then has to go to the prime. Depending on how many layers down you have, this could get really complicated. And remember, we said earlier, you normally have a 1 year deadline. So you've got 1 year to do all this and roll this up. When a prime is settling with a subcontractor or a higher tier sub is settling with a lower tier subcontractor, the FAR tells us you shall settle with subcontractors in general conformity with the policies and principles relating to the settlement of prime contracts. In other words, the same general principles that apply to primes, primes should apply to subs. We talked about cost reasonableness, and we've talked quite a bit about cost reasonableness. One of the elements of cost reasonableness is arm's length bargaining. What does that mean? It means that it means a lot of things, but one thing it means to illustrate is that a prime should not just accept on face value its subcontractor's settlement proposal. From time to time that happens. A subcontractor will say, here's my termination claim. Not giving you any financial data, or I'm giving you very limited financial data. And the prime says, I'm not going to review this. I can't really tell. Let's just see what the government says about this. That is what the government does not want you to do. The government wants to see arm's length bargaining. They want to see the higher tier contractor look to the lower tier and go, demonstrate to me that I'm actually liable for this. It can be a really helpful exercise to imagine for a moment, what if the government wasn't here? What if the government wasn't reimbursing any of this? What position would you take? It's a great guideline when thinking about settling with subcontractors and helps make sure you're in a position to justify your settlement agreement to a contracting officer who ultimately has approval authority for most dollar value. For some lower dollar value things, COs can grant settlement authority to a prime. So how do you deal with the sequencing problem? Knowing you got to settle with subs and then roll it up to your CO. What you want to do is communicate early and often. Get your contracting officer involved. Make them aware of what you're doing. Keep them read in. That also helps to avoid disputes. But what if you can't settle with your sub? What if the prime and sub just cannot come to an answer? Well, FAR Part 49 recognizes that might happen. It actually says that final judgment in litigation with a subcontractor can be considered part of your cost. And if a prime is really unable to settle with the sub by the time of that 1 year deadline, then you go to your termination contracting officer and you work it out. You get an agreement to carve it out. You might get some type of tolling agreement, but just don't miss those deadlines. Don't if you have a deadline to submit your termination settlement proposal, you've got to meet it regardless of whether you have been able to terminate with your reach termination settlements with your subcontractors. All right, we have another question. Morgan, take it away.
So contractor X signed a 1-year lease on a building it needed for a new federal contract. The federal contract had a 1-year term, but was terminated a few weeks after award. Are those lease costs allowable? Go ahead and throw answers in the chat, Q&A, whatever you're able to access, or you can raise your hand and we can call on folks. But Evan mentioned this, so this is going to go back to the reasonableness of it, right? So you've signed a 1-year lease. That seems pretty reasonable. Most landlords are going to go for a 1-year lease. If you had, say, a 30-year lease, maybe not so reasonable then if you were trying to seek out some of those costs. So again, this is a question of reasonableness. And we see a 1-year lease, that checks the box most likely for reasonableness. And likely those lease costs are going to be allowable. Now, that being said, let's see do you have a termination clause in there, right? So perhaps there's a 6 months termination kind of clause in that agreement. Okay, you might be able to recover then those 6 months, but then you need to work to have that termination set up with your landlord. You could also look, let's say it's a slightly longer lease. Perhaps the government is going to expect you to try to find a person or another company to come in and substitute and take over that lease. So let's say you have a 5-year lease. Can you find someone to come in and take that over? What would be reasonable for that? If you're in Denver or Washington, D.C., you probably can find another party who can come in and take over your lease. Are you sending something into space and you have a large facility in the middle of the desert in Nevada? Probably going to be a little bit harder to have somebody come in and fill that lease in. So that kind of shows you that there's this range of reasonableness. But in the example that you see here, 1-year term terminated a few weeks after award, you're probably going to be able to get those lease costs as long as if there is some kind of ability to terminate the agreement, that you're kind of working to do that, or otherwise at least some effort to see if anybody could come in and take over. And then Evan, if you have anything to add, otherwise I'm going to go ahead and I will move to the next slide. And Evan's going to close out our presentation today talking about costs after termination, adjustments for profit, and then adjustments for fee on cost type contracts. So some good stuff to close out the day.
Yeah, so these are all special items. We could spend a lot of time on each one. Given the time remaining, I'm going to do a lightning round of topics, of special topics and terminations. So one is employee costs after a termination. Again, it's the same cost reasonableness question. What did you do are these costs that you needed to incur? Are they reasonable in nature and amount? You may have severance costs for employees, right? You may have federal, state, or local law, depending on the circumstances of employment, may mandate a notice period. There are things like the WARN Act and various state WARN Acts that can require ongoing payment to employees, even if the company determines that it's not going to need their services in the long term and needs to do a reduction in force. Severance costs paid to employees. So there's sort of two angles of that. One is ongoing costs paid to employees required by law. That's just a basic matter of cost reasonableness. Severance paid to employees is going a little bit further. Severance is an allowable cost to the extent required by law, employer-employee agreement, or established policy that effectively creates an implied agreement with employees. There are other circumstances where it can be required. The point is, if you need to pay severance to employees, the cost principles do address that, and you're definitely going to want to consider it as you think about your severance plans. There are rules for mass severance. Those are accruals for mass severance. So in other words, the government is generally skeptical of accruals anticipating a large-scale reduction in force effort in the future, but the government recognizes there are times when there's mass severance, and I think termination of a contract can be one of those situations. And the government recognizes its obligation to participate, and this is the language they use, to the extent of its fair share in any specific payment. The government will consider allowability on a case-by-case basis. There's no bright line rule for what constitutes mass severance. I would say if a company needs to engage in layoffs of tens or dozens of employees, you may be headed into that direction. Any more than, very likely so. There are also instances where in a termination, you may need to pay incentive compensation to keep employees on the job. Sometimes employees will recognize a contract's been terminated and they want to move on to another opportunity, and they don't, but you need them to stick around to administer the windup. Well, in that type of situation, it may be reasonable to pay your employees more to keep them there. You're just going to want to document if that's the case, right? If you have a retention bonus or some other incentive comp structure, you're going to want to document why that was necessary. So that's one special topic. Another, partial payment. Termination settlements can take a long time. I hate to say it, they can actually take years. It's unfortunate. It's just part of the process. It can leave you waiting for payment for a while. The FAR recognizes this problem and actually authorizes contractors to request partial payment. That means payment in advance of a final settlement on the form prescribed in the FAR in Part 49. The government's supposed to process applications promptly. Subcontractors can submit claims through a prime. Okay. There's a form, it asks for a lot of information. It's basically its own little settlement process itself, except it's not final. This can get you some cash flow. This can be really hugely beneficial. But it's important to remember these are advance payments. They're kind of in the nature of a financing payment, which means the government could make a final determination that the payment was improper and ask for it back plus interest. So you usually want to narrow this to things that are really not even close to disputed. And it helps because you need the government to agree. So if the government thinks there's some risk of a dispute, they're going to be less likely to do it. Adjustments for profit. Fair profit is permitted in a termination settlement. Lost profit is not. Does everybody feel they understand the difference between that? Fair profit on costs incurred is allowed. Anticipated profits that you're not going to get because the agreement has been terminated are not. Okay, so there's a distinction there. Just because you can't get your anticipatory lost profits doesn't mean you can't claim fair profit on work done. Okay, so the FAR addresses this. This is in 49.202. This rule explains that when you're considering profit, you should not consider the dollar amount of a subcontract settlement, but can consider effort in the settlement. Okay. There's a variety of profit factors to conclude. What's a fair profit in your termination settlement proposal? Well, it's called a proposal for a reason. It is a proposal. The government's going to evaluate it. What's a fair profit? You can make arguments about what you think is fair under the circumstances. Perhaps the termination put you in a very difficult position, and administering the termination added complexity to the work that makes the profit rate in your contract not reasonable for what you had to do. There are various factors to consider: extent and difficulty of work done, efficiency, reduction of costs, economic use of materials. A lot of the time you will see people use the same profit rate that was negotiated in their agreement. So if they negotiated, say, 5% in their agreement, they'll ask for that, and that can work. But the government may want to adjust that down. You may want to adjust that up. Just be mindful that that actually is an option. It's not. You can claim fair profit on a wide variety of your costs incurred. Flip side of that is you cannot get better. You cannot get a better outcome because of a termination for convenience than if the contract was fully performed. I'm going to say that again. You cannot use a termination. This is the principle the government applies. You'll see this in the case law. A contractor cannot, as a result of a termination for convenience, end up in a better position than if the contract was fully performed. What that's getting at is if the contractor was in a loss position, then that loss position needs to be factored into the settlement. So, of course, if you have a fixed price contract and you are obligated to perform it to the end, even if you're losing money, you have to continue it, right? So the FAR sets out some guidelines for determining that and making an adjustment based on a loss ratio. There's a couple of formulas for that. We won't get into this, but just be mindful that this is there. This is something you're going to want to consider. It can be one of the areas of debate is, well, how do you know you were on a loss trajectory, right? That's fundamentally an accounting question and get really into the weeds on that. This is one of those areas where I think it is prudent to get assistance from accountants or legal experts to help you navigate this type of an issue. Another special topic, deductions and completed end items. If you're going to keep goods that you otherwise would have sold to the government, you have other uses for them. The government, you can expect to say, does not think the costs for those are reimbursable to the terminated portion of the contract. Right? In other words, if you're keeping something for your own value, the government's going to want to see a deduction for that. They might consider things about termination inventory that's lost or damaged. Again, this is why it's important to maintain, preserve, and protect property and inventory. There is a connection here to completed end items. If you have a completed end item, you finished work. This is for contracts that are generally about delivering unit deliverables. If you've got it done, well, then, and if the government accepts it, then they got to pay the contract price for it, right? That's not even sort of a termination matter. That's just the contract. They accepted it, they got to pay the price. If there are undelivered but completed end items, the TCO is supposed to have those inspected and accepted if they comply and decide what's being delivered. They can decide they don't want it. They can decide, hey, thanks, you have acceptable units. We don't want that. So don't incur the shipping cost to send it to me. But if you have completed end items, you're going to want to think carefully about whether you have a claim for the full contract price of those completed end items. This is another area where there can be a lot of money on the table, and it's something that may not jump off the page as you are working through your termination settlement. I want to there's a couple other slides I want to talk about, so I'm just going to speak to this one very briefly. You can also get adjustment of fee on cost reimbursement contracts. Similar kind of situation, you consider the factors that you think are relevant to a fair fee. Just know that this is something that is also up for debate if you have a terminated cost reimbursement contract. We have a question, but in the interest of time, I want to skip through it because there's another couple of slides I want to talk about in terms of special topics, including termination of commercial contracts, meaning commercial product or service contracts within the meaning of FAR Part 12. As I imagine many folks on the line know and are familiar with, FAR Part 12 provides streamlined regulations and rules for when the government is acquiring products or services that qualify as commercial. There's a multi-part definition of what qualifies as commercial, but at a very general level, it's talking about products or services that are offered to the commercial marketplace, that are actually sold to the commercial marketplace, excepting perhaps some minor adjustments or improvements. FAR Part 12 contracts have their own termination for convenience clause. It's in FAR 52212-4L. That has a two-part test. It's a little different from what we've been talking about. It focuses on price. The first prong, percentage of the contract price reflecting the percentage of the work performed prior to the notice of termination. So you look at how much work did we do up to the point of termination, what percent of the price is reflected in that work, that's what you get. Plus, reasonable charges resulting from termination. The reasonable charges part sounds in practice is much more like the cost-focused issues that we were talking about a moment ago. What really makes Part 12 unique is this item number 1, percentage of the contract price reflecting the percentage of work performed. Okay, sounds easy. How do you apply that? Well, it depends on the type of contract that you have at issue. If it's something where there's a unit price, right? If you have unit prices and you have units, like you're manufacturing a product and you have unit prices for those products, the ASBCA has said you can measure the percentage of completion for each unit and multiply that by the contract price. So if you have, 10 units that are halfway done, and those 10 units had a price of $10 on each one, and they're halfway done, well, then you would claim $50, right? You're 50% of the way through those units. But it can get a little bit complicated because not everything is unit pricing. There is another decision involving software as a service where there was a 12-month license fee and the contract was terminated after 10 days. And the board said, well, 10 days out of 365 days is 2.74%. So that's the price, right? This goes to show you want to think about what's the fair and reasonable way to account for the percentage of price for the work that you've done prior to termination. There's no one-size-fits-all answer to that question. Termination of commercial product or service contracts are not subject to FAR Part 31 cost principles. However, accounting rules still apply, and those FAR Part 31 cost principles can still be very helpful guidance in thinking about these issues. So while the cost reasonableness principle per se doesn't apply, the cost reasonableness concept very much does. And there's a variety of ways that can work out, including the general common law obligation of every party to mitigate their own damages, right? To not do anything that runs up the damages. So what can you do to reasonably mitigate your own damages? Very similar to cost reasonableness. Again, this is an area where getting outside assistance can go a long way. You might have consultants that recognize gap cost issues that could be really valuable. Issues like impairment, gap impairment of capital assets. I mean, that can be real money on the table you would not want to miss in administering something like this. Now, couple of points on the mechanics. We got 2 minutes left. Part 12 doesn't impose a 1-year deadline on settlements, but you should still be mindful of time. It's pretty good to use that as a rule of thumb. Talk to your contracting officer. Come up with a schedule. You can also agree on other sorts of requirements that you want to work out with your contracting officer to expedite the process. Just think about the process. Think about where you might trip up or where it would be better to have agreement in advance. Try to get a little roadmap at the beginning with your contracting officer where you're headed. We've got a few. Let's see. Somebody has a comment that says, I'll read it. I don't know if everybody else can see this. Don't go it alone when you're dealing with DCAA or DCMA. Get professional assistance. I'll put it like this. Their job is not to help you get this done, right? So it's good. It's good to get assistance if you need it. Okay, last special topic, and then I'll stop. You may get a termination for convenience after a protest. Okay, in the event of a winning protest, the agency takes corrective action where it terminates the contract and goes back to the beginning. That is a form of termination for convenience, and there actually is a termination for convenience right in FAR 52233-3, a termination settlement proposal right that allows a contractor to claim termination costs. Another closely related concept is you can claim your stop work costs. And by the way, that's generally true. Stop work orders often are treated like changes or delays under the changes clause, which give rise to similar claims for costs. Sometimes the government's thinking about terminating, it'll give you a stop work order first, and you might have stoppage costs. It has the same kind of concept of what can you do to reasonably reduce your costs. Just be mindful of that there are a variety of ways this can appear, including following a protest, and you have rights there as well. Okay, that brings us to the end. I have, for CLE purposes, just a brief statement that I need to read. Morgan, was there anything?
You've got one last question in the chat if you have a minute to quickly cover it. one, I guess I can answer. John, we will get a copy of the presentation slides. I think we can circulate that. We'll work with the team on that. And then it looks like Matthew said something, kind of a question. I'll read it out really quick. So the limited termination costs available for commercial items is a reason to be wary of commercial contracts for products slash services for which there is no commercial market and there are a lot of sunk costs, right?
I think that's a fair statement. Yeah, Matthew, I think that's if you had no other place to, I don't think you'd be completely out of luck in recovering costs. But the government, this is one of the things the government looks to in commercial terminations, is it presumes what's a commercial item, so you have a commercial marketplace. You can go find somebody else to buy it. If that's not the case, yeah, it could be a lot harder. We have a checklist here. We will circulate the slides. Just briefly, our contact information is here. If you have any questions about this, please don't hesitate to reach out. We are happy to talk with you, happy to talk through the issues. Thank you very much for being with us here today. We appreciate it. Just briefly, I'm going to read a little statement about CLE. Thank you again for participating in today's CLE webinar. In approximately 30 business days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in New York or New Jersey. Have a great day, everybody. Thank you again very much for participating. That is the end of our presentation.